What is Medicaid's estate recovery program? As people age and their healthcare needs increase, many turn to Medicaid to ease the financial burden of long-term care. But what some don't realize is that Medicaid isn't simply a benefit, it's a program that may come with a cost after death. In New York, Medicaid's estate recovery program allows the state to recover funds from the assets of a deceased recipient. The legal framework behind estate recovery under New York law: if a person receives Medicaid benefits after the age of 55 or while permanently institutionalized, the state can seek reimbursement through estate recovery. This typically involves claiming assets from the estate to repay Medicaid for services provided. The scope of recovery is now limited to probate assets only, after a change in the law repealed the ability to claim non-probate assets such as jointly held property or designated beneficiary accounts. That repeal, enacted via the 2012-2013 budget bill, now restricts recovery to only those assets that pass through probate, such as properties solely in the deceased's name. Medicaid estate recovery cannot proceed if the deceased has a surviving spouse, a child under 21, a blind or disabled child, or if certain caregiver or sibling residency exemptions apply. The law does permit placing a lien on a home if the recipient is institutionalized and not expected to return home, but this lien is restricted by several exceptions and does not allow for immediate repossession. How to protect your estate from Medicaid recovery? Protecting assets from Medicaid's estate recovery starts with early planning. Creating an irrevocable trust, often called a Medicaid Asset Protection Trust, is a key step. This type of trust must be established at least 2.5 years before applying for home care Medicaid or 5 years before nursing home Medicaid. Once assets are placed in such a trust, and assuming the proper timeline is met, they are no longer considered part of the estate for recovery purposes. Individuals can also create a life estate, giving them the right to live in their home for life while ensuring it transfers directly to a named beneficiary, bypassing probate. Spending down assets strategically, purchasing long-term care insurance under New York's partnership program, or transferring property before the look-back period begins are additional legal strategies that may reduce exposure to estate recovery. Understanding the Medicaid estate recovery process. The estate includes all assets in your name at the time of death, real estate, bank and investment accounts, and retirement funds. If these go through probate, they are fair game for estate recovery in New York. However, assets passed through a trust, or held jointly with rights of survivorship, generally avoid the recovery process. The Medicaid Estate Recovery Program only applies to those 55 or older, or permanently institutionalized. Those enrolled in programs like QMB, SLMB, SHE, or QDWI may be exempt. For recipients receiving coverage for in-home care, community services, nursing homes, or hospital stays, the state will attempt to recover these costs unless legally protected planning measures are in place. Safeguarding your family's future. Planning ahead with a lawyer is critical to avoid the financial burden Medicaid estate recovery can leave on your loved ones. An attorney can explain the legal nuances, set up irrevocable trusts, and ensure your home and financial assets are protected from state claims. A law firm with experience in Medicaid planning can build a compliant and strategic plan that safeguards what you've worked a lifetime to build. Contact Schlessel Law PLLC to start your estate planning journey today. Call 516-574-9630 or visit us at 34 Willis Avenue, Suite 300, Mineola, New York, 11501, United States.